if it's a known disability and you ask for an accommodation, there has to be what's called at least interactive dialogue. So, and you don't have to know as managers and leaders which disabilities are covered and what aren't, but what you do need to know is you can't say, that's ridiculous, just buy it yourself, right? Let HR make that call. That's that yellow flag where there may be some type of an accommodation that's reasonable that your company can make for this employee. So another thing is that where this act was significantly amended is more disabilities are now covered. So what is now a covered known disability? Stress. So what if I go to HR and I say, my boss is completely stressing me out and I need to have every other Friday off. Can I do that? No, right? Well, first of all, I would have to have documentation from a medical doctor that I have stress, right? So I can't just say, I'm stressed, I want you to make that accommodation for me. And what if it's not reasonable? What if I even have medical documentation, but Fridays is the critical crunch time where my job is required to be in-house because that's how the organization functions, right? So then maybe that request is not reasonable. And this is what ends up in the courts a lot. What's reasonable and what's not reasonable. So again, we'll talk about that one a little bit more, and it was amended in significant ways, but that's just some examples. So these laws are constantly evolving, constantly changing. But the important thing is that we now know that the American Disabilities Act, Amendment Act, is what people are talking about when they talk about ADA or ADA-AA.